Hello friends, in today's video I am going to talk about the right way to gift a property from an Indian parent to NRI children's. So I am getting a lot of this question where the parents are getting old and they want to gift their property to their children who are settled abroad. So I'm going to talk about legal and tax aspects of gifting property from Indian parent to their foreign children's in this video. So let's start. So hello friend, my name is Arun Tiwari and generally I make videos on NRI topics, NRI taxation topics or tax litigation topics. So this is my specialty, international taxation and tax litigation. So in this video I'm going to talk about the gifting part. Now what are the different way an Indian parent can give property or give their property to their NRI children's, that I'm going to discuss in two aspects, legal and tax part. So first understand what are the different way. So first way a parent can gift a property to their NRI children is by a gift deed. So they can gift a property directly instead of selling it, right? Now what is the legal point of this? Gift is totally legal if the property is self-acquired by Indian parents. Now let's talk about the tax part. There is no taxation, no tax on gift. So earlier there was a gift tax, but now that is abolished. If an Indian person, Indian parent are gifting a property to their NRI children, there is no tax on that. Now under what circumstances it can be beneficial? Where the NRI children want to retain the property. It can be a property where their parents are living, and okay, or maybe a property which they want to retain so that when they come back from abroad or want to settle down in India, they have some places to live. So in that condition, it will be ideal to gift them, right? So that they can maintain on their name and the all dispute related to property is settled before the eyes of the parents. Because what happens if somebody makes a will, it generally settle when they are not around. So in that case, there can be disputes. So if in certain situations, suppose parent feel that after when they are not around, this property may get into dispute, the best part or the best way is writing a gift deed and getting a registration for that gift deed today itself. Now understand one important part. If your parents are gifting you like residential property or land, it's always advisable to make a gift deed registered. In other cases, normal gift deed will also be fine. Like if they want to give jewelry or other movable assets, the normal gift deed will also do. But in case of registry and all, the property and all, registration is very important. So first part. Second way, as already all of you know, is making a will. So parents, when they are alive, they can make a will and they can decide how much they want to give to with children. So gift is easier way. When they are around, they can segregate, okay, and they can only retain a right to live in this property if they are gifting some property which is where the parents are living. But suppose they don't want to do it because maybe they feel, what happen if the children become something like a Bagma movie and expelled from their own houses? This may be a genuine reason also. So in that situation, making a will is better. So there is a second option. This is a second option. So in making a will, what they can do, they can divide all the property between the children and they can make this will registered. And then they can appoint an executor. Now executor can be from family, can be somebody who is independent. Generally, they can appoint two executors. So already I made some videos on how to make a will. You can just go through. If you need any advice on the will, then definitely I'm going to help you. So one more thing, there is one problem in the gift which is not there in the will, right? So when you are making a gift, generally you should gift your self-made properties. If it's an inherited property and suppose your parent have, like you have more than one sibling, right? Maybe one person is, one son or daughter is living in India, one is living abroad. There may be dispute if parents gift inherited property to one of the sibling and they don't disburse this amount as per Hindu Succession Act. There can be dispute. So suppose if a parent, Indian parent, only have self-inherited property, like self-acquired property, which they have bought from their own savings, there is no problem creating a gift deed. But if they want to distribute self-acquired property plus inherited property, making a will is much better than making a gift deed. Because will is enforceable by law, gift can be disputed. right? So second option, where the parents want to sort out all the disputes including the property which is inherited, they can make a will, and in the will they can clearly mention that who is going to get what. And the good point about the will, till the time they are alive, nobody can touch that property, nobody can make any kind of claim on that property. So till the time they are like parents are there, they can enjoy their like property, the proceeds of that property, and only once they are not around, children can come back and they can get their property as mentioned in the will by enforcing it in a court. Now, what is the legal point of will? So, as I told you, if the will is registered, although it's not required, but if it is registered, it cannot be disputed. It cannot be taken to the court. So, always it's better to get a registered will, even it takes time, and appoint at least two executors so that at least you can remove whatever hardship can come or maybe biasness can come from one executor. So one executor you can keep from your family, another executor you can keep as a professional, maybe your CA, your doctor, your lawyer, whoever you trust. So the legal point is that if it is registered, there is no problem at all. Okay. Now let's talk about taxes. So what is the taxes going to be paid when the children are going to get this property? Now again, like a gift, if you're receiving a property in inheritance, there is no tax, right? Only when you're going to sell this property which you receive as an inheritance, then only the person has to pay taxes. Till the time they are retaining, there is no tax on inheritance. So there is no inheritance tax in India. Now let me talk about third option. What is the third option? Now some parents want that when they are alive, they are around, they should sell the property and send the money abroad so that there should not be any problem. Their children should not face any difficulty coming down to India and finding a buyer and selling and all these things. This is also a very good idea, especially in the case where the property is very vast and the children may not get that much time or they may not be very familiar, and in a situation where the property is agriculture, because there may be a lot of issues also which children might not be even aware. So in that case, of course, it's very well better that the parent itself take an initiative and they find some buyer and they sell it, they send the proceed to their children who are living abroad, which they can use for whatever purpose they want. Now let's talk about the legal point of this. If you're selling the property when you are alive, when the parents are alive, so whatever tax is going to come, the parents has to pay all the taxes. When they're going to send money, there will not be any tax, but there will be 20% TDS on that, because they're sending money abroad. Now this 20% TDS is not a tax, it's a kind of advance tax which parent can file a return and can get a refund. So a lot of time I get this question, so why this 20% additional, my parent already have paid taxes. So this 20% is not tax, it's a kind of advance tax which government collects only to ensure that person who is sending money abroad should not move out India without paying taxes. So it's possible that parent can sell all the assets, send all the money abroad, and then they move out also. It's possible. To avoid that, they charge additional 20% TDS on the money sent. Now there is another option which I will tell you. It is possible that parent, when they are alive, they can give a gift to their children and their children can sell the property and take the money abroad. This way they can avoid double TDS, because when NRI themselves are selling property, they have to pay tax once, but when they are taking money abroad, they don't have to pay TDS again. So this is a smart move. I told you both the option, right? So third option I told you, when parents feel like it's better to sort out matter myself when I'm alive, when I'm around, rather than putting all these things to my children who might not be aware of this, like agriculture land, joint properties, all these things. So in that case, always is better than when they are around, they either gift the property to their NRI children and then can sell it and send it money abroad without paying double TDS. But if parent want to do everything and they don't want to bother their children, they can still do it, but then they have to pay double TDS. But the second TDS which they have to pay when they're sending money abroad will get as a refund. So hope friends, these points I covered very well, the legal and tax part also, for what is the best way and what is the better way of gifting a property or giving a property to NRI children's by Indian parents. So if you got any other question about property sale, or maybe you get any kind of notices, please contact us. Please send your queries in comment section. Please don't put your personal details there on comment section. Send a mail id is there on front, phone number is also there for client support. You can call them. They are going to definitely help you. So that's all in this video. If you like this video, please share with your other NRI friends and subscribe and like also. That's all in this video. Thank you. Have a nice day.